Senators, I mentioned at the outset, the vast majority of what you have now heard of the evidence is uncontested. So what are the issues here? There are really two arguments the defense will make, and the central one is this: Porteous did nothing wrong. Judge Porteous may have done all of these things, but there's nothing wrong with any of it. None of it was unethical, improper, or wrong. It is nothing more than an appearance problem. He is being impeached essentially for having lunch. That is the gist of the defense. Now, there'll be a suggestion that Judge Porteous may have done all these things, but the House chose not to charge him with a violation of the kickback statute, 18 U.S.C. Code Section whatever. When, as the Senate has already made clear to counsel, this is not a criminal case and the House has no obligation to charge or prove the elements of a particular statute. There'll be a similar suggestion that the House has not charged a violation of the Honest Services statute, when, of course, he is not charged with violating the statute either, nor is the House required to make a charge of a particular code section. There'll even be a suggestion that, after all, Senators, we're talking about New Orleans. It's New Orleans. They all do it, and if you're going to impeach judges in New Orleans for this kind of stuff, you're going to have to impeach all of them. There will be a hint of that. But the real argument is he did nothing wrong. And on this, the House could not disagree more. We believe that the evidence in this case fully supports the view of the House of Representatives that sending court cases to a law firm and taking cash back is wrong, dead wrong. The evidence will show that allowing yourself to be wined and dined by lawyers who have a case before you is wrong. The evidence will show that allowing those lawyers to pay for parties, to pay for your lunches, your liquor, your hotel room, to have a stripper dance in your lap, all of that is wrong. To falsely represent your financial relationship with lawyers in the courtroom is unethical and wrong. The evidence will show that to solicit cash from lawyers with a multi-million-dollar case under submission in your courtroom is wrong. To set bail based on how much it will benefit a bail bondsman is wrong. To accept car repairs and home repairs and lunches and liquor from that same bail bondsman is wrong. The evidence will show that to expunge the convictions of their employees, to recruit other judges to form the same corrupt relationship is wrong. To file a false petition in bankruptcy is wrong. And we believe that when you hear the evidence, the uncontested evidence, you will agree it is wrong and that he must be removed from the bench. There's a second argument the defense will make that I also want to comment on very briefly, and that is the Senate cannot consider the evidence of any of Judge Porteous' conduct before he was sworn into federal office. As Representative Goodlatte's evidentiary presentation made clear, some of the conduct in Articles 1 and 2 took place before the judge's appointment to the federal bench, during the confirmation, and after his appointment to the federal bench. Article 3, the bankruptcy count, involves conduct only while he was on the federal bench, and the final article, Article 4, involves conduct during the confirmation process itself. In Judge Porteous' view, the Constitution prohibits the Senate from considering in an impeachment proceeding anything that took place before his swearing in. The Senate confirmation process, in this view, is a high-stakes game of hide the ball. If you can get confirmed, no matter what you conceal, no matter what false representation you make, you are home free for life. Nothing in the Constitution compels this view. In fact, the Constitution is silent on when the high crimes or misdemeanors must take place. But Judge Porteous would have you read into that silence an intent to make any prior conduct unreachable. This would lead to an absurd result. Let us say the evidence showed that a judge had committed murder prior to his appointment. Could he not be removed? Let's say that the evidence showed that a judge were convicted and sentenced to jail after their appointment to the federal bench, but based on conduct that was committed before they were appointed to the federal bench. Can we imagine a situation where that judge might serve the rest of their life in jail and the Senate would be powerless to remove them or withdraw their salary or pension? In this case, the defense makes much of the fact that Judge Porteous was not prosecuted by the Department of Justice, but let's say that he had. Let's say that he had been prosecuted for the curatorship scheme. It would be the defense's position that because the conduct took place before, notwithstanding that he goes to jail now, he cannot be impeached or removed from the bench. As Professor Amir, one of the nation's leading constitutional scholars, testified before the House, if a judge bribed his way onto the bench, would he be beyond the reach of impeachment? Of course not. The standard, we believe, for impeachment is whether the judge so misdemeaned himself that he has betrayed the public trust and cannot be allowed to remain on the bench. Viewed from this perspective, it matters not when the conduct took place, but whether the public can have confidence that the judge will honestly and honorably undertake his public responsibilities and in accordance with law. In this case, we believe the evidence will show that the public cannot have that confidence. Let me conclude where I began with one final observation on the standard to be applied as you hear the evidence. What does it mean to betray the public trust? I can only give you my view, and that is, if I were a member of the public and I had to appear in Judge Porteous' courtroom in the future, could I have the requisite confidence that he would undertake his responsibilities in accordance with the law? If I had a case in his courtroom that was very important to me, and opposing counsel was a friend of the judge, could I be confident that he was not taking cash for them, that he would disclose his full relationship with them, that he would not ask for more cash while that case was under submission, that I would not need to hire another crony of the judge to protect myself? I could not have that confidence. If I were a creditor in a bankruptcy case, could I expect a fair result when the bankrupt party lied on bankruptcy petitions, used an alias, concealed debts, or violated the court order by incurring new gambling debts? How could I have that confidence when the party in question can say, Judge, how can you criticize me for filing under a false name? Doesn't the name Porteous ring a bell? And with that, Senators, I will conclude my remarks.